I think at best we return to the world of 2015, in which the ATF guidance was your arm brace is generally okay, but if you shoulder it, it's an SBR and you're in big trouble.
Yeah, so
I think we have to get back there.
we are the Armed Attorneys. Today we're talking about a great nationwide opinion as it relates to pistol braces. We're going to be talking about the legality, what the government is going to do next, and how does this rule interact with the recent decision we got in Cargill v. Garland, and that's our bump stock case. But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is brought to you by our friends over at Aura.
You may have received the dreaded letter about AT&T's data breach, which revealed the private records of former and current customers, and now all of that sensitive information is on the dark web. It's just one of the major breaches that happen every single year.
But there's a way to protect yourself, and that's why I'm excited to tell you about today's sponsor, Aura. You've heard me tell this story before. I tried it out for myself. I Googled one of my sister's phone numbers and immediately found her home address, which is pretty horrifying because as a former felony prosecutor, her information is supposed to be hidden by law.
But that's where Aura comes in. Aura has almost every internet safety tool you'll ever need all inside one app. The app features a VPN, password manager, real-time credit and identity theft monitoring, internet parental controls, and protection for devices from malware. These tools are crucial if you want to protect your bank and social media accounts or other sensitive information.
And on top of data breach notifications, Aura proactively identifies data brokers exposing your information on the dark web. They'll even submit opt-out requests for junk mail and telemarketing lists.
Aura's always on, provides incredible peace of mind, and does all the hard work of keeping you safe online. Better yet, if you sign up right now, Aura will give you a 14-day free trial with our link. So if you value your privacy as we do, go to aura.com/armedattorneys to start your free trial, also linked in the description below. So we've got here Mock versus Garland. And this is something we talked to you guys about months ago, in which a court down here in Texas, a federal district court, issued a preliminary injunction against the enforcement of the ATF arm brace rule. And essentially, this was not a Second Amendment decision, but it was one that was based on the Administrative Procedures Act, which is what we have that regulates agency rulemaking. And they used a logical outgrowth test, which is not as boring as it sounds, because what we said is essentially, look, the ATF's proposed rule on pistol braces was so different from the final rule that was actually published in the Federal Register that there was no logical outgrowth between the two. And why is that important? Because in the nature of rulemaking, you have to give that proposed rule to the public. You have to provide them a notice and comment period. You have to give them an opportunity to participate, and then you publish your final rule. And it was like a bait and switch, right? So we had proposed rule, everyone flooded in with their comments, and then final rule had basically nothing to do with the proposed rule. And so it violated the Administrative Procedures Act. The government was enjoined from enforcing it. And we were all sitting around here knowing that litigation was going to continue, because a preliminary injunction is not a final injunction. And then, of course, even after that happens, there's more litigation to come. And so finally, after months and months and months and months and months of waiting and wondering where the permanent injunction is, we still didn't get it.
No, the court gave us a different remedy. They vacated the rule. So instead of saying, hey ATF agents, you are permanently enjoined, you are restrained from enforcing this rule as it relates to braced pistols, they completely voided the rule. The rule comes off the books, effectively, is what this does. And this is the district court level. And who is being affected by this? Well, the ATF's rule on pistol braces, braced pistols. Essentially, they were telling folks, hey, if you had a braced pistol, we're treating these braces as stocks. These things, if they don't meet all the other requirements, we're going to start treating these things as short-barreled rifles, and therefore you need to get a tax stamp and go through the whole rigmarole to comply with the National Firearms Act. Now, there was a little amnesty period. People got free tax stamps or tax-free items, and there's been a lot of questions about what happens to those items. You know, I got a tax-exempt SBR. What happens to me now? I guess we'll look and see what happens there.
Figure that out.
But for our brace pistol folks, and we get this question all the time, you know, assuming there's not something else going on crazy with state law, under federal law, these things are considered traditional handguns or pistols. They're not considered short-barreled rifles.
Right. So what happens next? And this is actually, I don't know, probably good news given the state of the law, but of course we're in for a long legal battle still. So what happened when we got this rule vacated is that the judge granted the plaintiff's motion for summary judgment. So for all intents and purposes, the case is over at the trial court. It is ripe and ready to move up to the Fifth Circuit Court of Appeals, who should, by all accounts, and we absolutely expect them to affirm this. However, that will take how long, Richard?
Yeah, probably a year.
A year. And then what will happen after the Fifth Circuit affirms?
I mean,
Well,
I
depends on
imagine.
who wins in November.
Sure. Well, I imagine Merrick Garland and the ATF are going to lose at the Fifth Circuit. They would, at that point, request the Supreme Court to review this case. But this is one of those cases where we
I
don't
mean, if
have.
we have a new attorney general, though.
Yeah,
we're not
yes.
gonna have that.
Well, probably not.
Probably not.
But we don't see any other district courts or circuits disagreeing with the court here in Texas or the Fifth Circuit Court of Appeals. And so when you don't have a circuit split and you have a nationwide, vacatur of the rule, that's one of those cases where the Supreme Court says, y'all got it right.
Yeah, I think so. I would not. Let's even say that that the Biden administration remains and Merrick Garland remains and does in fact, lose at the Fifth Circuit, appeal to the Supreme Court. I highly doubt this is a case that the Supreme Court does review, but I don't think any of that is necessary for the government to even still keep messing with us because they're shorter. We've talked about this before on the channel. They're shorter, easier way to continue to strip us of our rights is just to go back and propose a new rule that looks like the final rule that they want.
All right, and Emily and I are going to be disagreeing a little bit for the next couple of minutes.
Well, yes, we are going, but not about the fact that that's probably what they're going to do.
No,
that's probably what they're going to
And
do.
ultimately, yes, like Emily said, why this rule was overturned, not a Second Amendment case, an Administrative Procedures Act case. Remember that schedule where they were going to have this factoring criteria, and then if it met the schedule, we're going to call it an SPR.
Point system
They
and all that.
completely, there are still hundreds of videos floating around on the YouTube confusing people about that stuff. But they're not even, they didn't go with the schedule. They went with a completely different set of rules. So it raises an interesting question. What if we take the final rule as we have it now and start it as a brand new rule, brand new comment period, don't change anything, and then publish it? At that point,
Then it passes the logical outgrowth test.
then we are, rules of statutory construction. You try to resolve things on the lowest level as possible so that logical outgrowth, that's below what we just saw in Cargill v. Garland.
Right. So, so what happens if it logically outgrows? Then I think that we challenge this on Second Amendment grounds, on Bruin grounds.
Yep.
Maybe as much like Cargill, we start talking about ATF overreach in its legislating rather than rulemaking.
Yep.
But then this is where we disagree. What happens? What happens when this eventuality occurs and we start making those challenges? And my personal belief is pistol braces lose. I think they might lose.
I'm going to lean heavily on this long and storied tradition of this legal concept that I've been familiar with for my entire career, which is the presumption of ineffectiveness. And how do I show my napkin math? Well, and this was the reasoning in the Cargill case that we just talked about. They said, hey, look, if we don't include bump stocks in this definition, then basically everybody has found a workaround to the machine gun ban. And so therefore, Congress's purpose was frustrated, and that's why you got to prohibit this stuff. And the majority opinion in Cargill says, look, machine guns are still prohibited under the law that Congress passed. It's clear cut. It's black and white. And I think we can draw some analogies to this, although I will admit it's a little bit closer. But we see, hey, look, if we have a braced pistol, are we having this complete runaround of our, typical ban on short-barreled rifles without, getting permission from the ATF, obtaining a tax stamp? And I think that the arguments that are going to be made by Second Amendment advocate groups is going to be, hey, look, if you have something that's designed, made, or adapted, designed and intended to be fired from the shoulder, you got your rifle, and it's below those certain lengths, we still have bans on short-barreled rifles. And so while, yes, this may frustrate the purpose a little bit. We don't outright say there's a complete runaround of all of this, because if you had a, let's say, traditional stock on a short rifle, that would still be prohibited by Congress. And so I think that's the argument that's going to get made.
I disagree. I disagree
I
because
dissent.
I dissent. No, I'm not saying this is what I want to happen, but what I truly believe, because we don't have such a complicated, not that it's complicated, but we have a more complicated definition of machine gun. We have something that is more intricate than we have as a definition of what's a short barrel rifle. And so I think it's much easier to satisfy what becomes a short barrel rifle rather than what becomes a machine gun. And I think at best we return to the world of 2015, in which the ATF guidance was your arm brace is generally okay, but if you shoulder it, it's an SBR and you're in big trouble.
Yeah, so
I think we have to get back there. That's what I believe is going to happen, unless Bruin tears it down. But I don't know.
And so I think it really boils down to kind of those three doors rule. Can't stand, brace is fine, do whatever you want. We have rule upheld, and these things are treated as stocks and SBRs. And then door number 3 is, Emily, I think it's a really good observation. Braces okay, not okay to shoulder. We kind of fall back to where the ATF was a decade ago.
Right. But again, right now we live in a world of freedom, and we will live in a world of freedom until and unless, I believe, the ATF does issue a new rule, notice and comment, new final rule. But I just think that's coming. I think that's coming. I'm already preparing for it.
Yeah, we got a little bit of shell shock here.
Yeah.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And question and comment for us below. Until next time, we're the armed attorneys.